Hey y'all, welcome back to the show. Today's episode is a little different. I recently did a live legal Q&A with the folks over at Riverside FM all about legal for podcasters and content creators. It was such a great session covering topics like protecting your podcast content, liability when bringing on guests, and selecting a podcast name legally. I hope you enjoy this well-rounded episode. Let me know your thoughts in the comments if you're watching on YouTube, or you could submit a question form on our website, thebusinessofdoingbusiness.com, and we'll do our best to answer it on a future episode. Enjoy, and I'll talk to you soon. Peace.
For you today, we have a live legal Q&A for all of you. I know that a lot of you in the community have a bunch of legal questions that you have, so we decided to bring in an expert to answer some of your questions and give you a little bit of guidance. So feel free in the chat as we're going to send in your questions. For now, feel free to introduce yourself in the chat. Let us know where you're tuning in from. But our legal expert here, I'm really excited about this event, is Yasmine. Is Yasmine Salem Hamdan. Apologies if I just said Hamdan.
You're great. No, okay. You're great. That was awesome. Hello.
And
thank you.
So intellectual property attorney and entrepreneur, and also a podcaster yourself. And she deals actually directly with podcasters and content creators. So this is just such a perfect fit. I'm excited to dive into it. But before we do, why don't you introduce yourself to the group?
Yes, thanks, Kendall. Thanks for inviting me and for an awesome collaboration. And thank you everyone for joining us. I am so excited to be here and to talk about all things podcasting and to help answer your questions around the legal stuff and protecting your content and really protecting yourself as somebody who's putting yourself out there and creating original content, and just exploring creativity and problem solving and just all the awesome things that come along with the world of, content creation and creating community and putting your voice and perspective out there. So thank you again for having me. My name is Yasmine. I'm a business and intellectual property attorney. As you stated, I'm based in Dallas, Texas. I have a startup called Coaches and Company. It's coachesandcompany.com. We provide access to business education and legal resources and tools like our contract templates. So we offer downloadable contract templates that are designed with digital business in mind. So for those people who are selling services and digital products online, many of those individuals are also creating content via podcast, via social media, YouTube, etc. So I agree. It's a great fit, and I'm really excited to shed some light today on some of these legal issues and looking forward to everyone's questions.
Yeah.
Good morning, everybody.
I was looking through your template and all the templates, and I was like, there's so many great things in there. I'm going to share a little list of the kind of templates that you have at the end. But that's coachesandcompany.com for anyone who's looking for some legal templates. But my first question kind of off the bat to you, as others, you can send in yours, and I have a few prepared and some that were sent in from the community before we started. What would you say is the biggest legal mistake, the most common kind of legal mistake that you see out there for content creators or podcasters that are putting their content online?
Yeah. A couple come to mind when you ask that. I'm like, okay, yeah, definitely that. But then there's also that. So I'll just go with what my gut was. Yes, I'll go with my gut. And the first thing that came to mind when you asked that question was using other people's content without permission or authorization. So that's something that people can do, somewhat innocently. They don't necessarily mean it maliciously or to cause any harm to the other party, but it's important for us to understand that all content is owned by somebody. So we've got to make sure that we are, being respectful of that, being mindful of their rights as it relates to their intellectual property. And so that includes music, that includes photography, videography. Many of us are familiar with stock photo websites and stock video or audio websites. And there are many websites out there where you can pay a small fee to use an audio commercially, maybe as part of a jingle in your podcast intro or the background music in a YouTube video or something. And so it's really important to be mindful of that. And that's a great way to be proactive around, avoiding committing any type of copyright infringement or intellectual property infringement. And I'm going to say IP for intellectual property. It is a bit of a mouthful, so IP for short. But being mindful of that. And that's one of the first, IP related mistakes that most entrepreneurs make is they think, okay, I found a photo on Google or I found a photo on Pinterest. Let me take that and put it on, my website and put it on Instagram or use it as part of my podcast cover art, for example.
That's, and that leads us really well into, we had a few questions about music. Mm-hmm. So, music, let's say that you are if you're adding music into your podcast, let's say that you have first you have stock music, the kind that we were just talking about, that you're able to go on these websites and download for a fee, different kinds of music. But if you want to play, let's say like a clip of a song or even a clip, I know I see on social media clips of videos, they'll reference a moment in pop culture and quickly play that clip. Can you talk to us about when it's okay to use that kind of music or those kinds of videos?
Yes. So that goes in the direction of fair use. And so there is a concept of fair use. And without getting too in depth here, because it's a lot and there's so much litigation that goes on around what is fair use and what isn't fair use. And people fight this fight out in court all the time. I'm sure there are dozens of lawsuits that are active right now related to fair use of somebody's content. And so I would say, as a general rule of thumb, if you're using it in your content, and you're using it in a reporting sort of way, or you're talking about, a pop culture moment, or you're using it to illustrate a small comparison or point within a larger body of work, if it is very, very brief, and is, and I'm talking in terms, if we're talking about time spent on the screen, like a second, and it's a 20-minute long video or a 10-minute long video, that is very minor, and that would not be considered, the bulk of the work or the body of work as a whole. So that is something you want to consider, is if you are showing a short meme or a short clip, then you're probably okay. Probably nobody's going to come after you, but I remember somebody asking me once if they could use the squirrel from Ice Age as a part of their logo. And then they said, okay, well, what if I don't want to use it as logo? What if I want it to be like a recurring character? Because the logo, of course, was no, you would need consent of whoever owns the rights to the use of that visual element, right? Somebody owns the rights to that character and the visual aspect of it. And I remember she said, okay, could I use it as a recurring character in my YouTube series and in my podcast? And still my recommendation was no. I mean, you could, but you definitely run the risk of, being hit with a copyright takedown where your videos could be taken down, your content could be taken down, because if it's a commercial activity you're engaged in, then you are, directly or indirectly profiting off of the use of this other intellectual property. And so you can use other people's IP. You should just make sure that you have their consent. So if she was able to get in touch with, I think that's Pixar that does Ice Age. If she was able to, secure a license from them to use it, I think that would be pretty cool, actually.
That definitely would. But good luck with that.
But good luck with that.
Yeah, exactly. Yeah. Well, Stefan had written, what about when somebody makes a commentary video about another video on YouTube, for example? So in that case, would you say that that's if you're using a few seconds of that, should that generally be okay?
Yeah, I would say it depends on whether or not you are, republishing that content with the purpose of I'm publishing this exact content versus is the bulk of the content your original content, and that's a minor part of the content that is being published. How many times can I say content in a sentence? I don't know. I guess we'll see.
We always will beat ourselves with this. I was saying today, I was trying to speak in a lot of acronyms, so send me the KPIs by EOD. And
you were speaking in code.
Now that you're saying IP, it's just adding to my day of acronyms.
I love it.
We have a few questions here that are coming up about disclaimers. So cool. We had a question that came in from somebody from the community, JD Marshall, who has an off-roading podcast. We talk about all things 4x4 and wheels on dirt. Should our podcast have a disclaimer playing before it goes live? Something along the lines of, don't try this at home, don't take our advice, we're not experts. So that's one question. But we also have a few that just came up on, there was a question, I think, from Anna about what's your advice talking about disclaimers using scripts or ad-libbing them? What is the bare minimum we should include to protect ourselves? Let's say we want to investigate something like we want to discuss an ongoing investigation. Another question is about talking about psychedelics, adding a disclaimer that it's solely for educational purposes. Doesn't matter where it's added. So let's talk about all things disclaimers and when a podcast should have them and what this should be included in them.
Okay, awesome. Great questions, y'all. I love this. This is like just music to my ears. I love it. And I love that y'all are thinking about these things. That's really great too. So, okay. When it comes to disclaimers, I like to think of them as something of an insurance policy. Like you'd rather have it in place to point to it if needed in the event that, somebody is seriously injured in an off-road accident on a 4x4. I don't know. Admittedly, I don't know much about 4x4s and off-roading, but
you can listen to
but if
JD's
that were to
podcast
happen,
and learn all about it.
There you go. But if a listener of JD's podcast was injured and said, well, I was compelled to do this or engage in this activity at the direction of the content of this podcast, assuming that there actually is not anything in the podcast that is saying like, hey, engage in this seriously dangerous activity or, whatever the other party says happened that led up to their injury. Assuming that's not in the podcast, having a disclaimer can be useful in that you could point to, okay, well, not only did we not have anything in our podcast that encouraged you or compelled you or tried to persuade you to take this dangerous action. We also made it very clear that, you should, and then whatever the disclaimer might be, don't try this at home. Don't, engage in dangerous activity, without a helmet. I don't know what that disclaimer at this point, depending on the context of the information shared on the podcast would be. But having a disclaimer that clearly states where the limits lie in terms of the content that's being presented. So, in the case of the psychedelics that in the chat, the question that was asked, and you're providing maybe on the podcast information about the use of psychedelics and the different types of information and questions and content that might be related to that, whatever the subject matter is, stating that this is for educational purposes, for informational purposes. This is not a substitute for, depending on what the nature of the podcast is, mental health therapy. This is not providing any diagnosis. This is not advice that should be substitute from, a physician. And that applies for if you're a health and wellness expert or a health and wellness podcast, if you are a podcast that is talking about money and finance, maybe you talk about budgeting, maybe you talk about investing, maybe you talk about saving, whatever that might be, being very clear that this isn't a place to receive personalized financial advice. And then don't cross that line, so that's the second part to it, is having the disclaimer in place can be helpful. It puts others on notice. It makes it clear where the lines are drawn, what the boundaries are. You can use it later on to point to in terms of evidence that it was in fact, like, I was not trying to provide medical advice or legal advice or financial advice to this individual personally. But then also, you can shield yourself from that in the event that somebody does try to, I don't know, blame their, the damages that they may have suffered as a result of something maybe related to your podcast. But you want to be able to, you want to have it and not need it rather than need it and not have it, right? Mm-hmm. Kind of like a contract too. You don't ever want to have to point to a contract with a client or with a business partner or with anybody that you're working with. But you'd rather have it and be able to point to it than need it and not be able to use it or reference it.
Absolutely. And on that note, disclaimer, this webinar is for educational purposes and not in place of hiring a lawyer.
Yes, precisely. I think we included that on our sign-up page.
We did.
Yes,
we did, exactly.
So we made it very, and I include that at the beginning of all of my trainings and the description of all of my educational offerings. And, I don't provide personalized legal advice because I need, full context in terms of being able to provide legal guidance. But, all of my answers presented today, I would not, tell somebody exactly what they should do and how to exactly navigate an active legal dispute or situation on a call like this. And I think that everybody should, apply that same caution whenever you're presenting information online. Understand that you can't possibly know every circumstance of a potentially sensitive situation or a personal situation if it's related to somebody's money and finance, their health and their wellness, their personal well-being, their business. So yeah, we've got to be mindful of where those boundaries are, and in our best interest to protect ourselves, and then also to protect our audience and the consumer.
Absolutely. We actually have a few follow-up questions.
Cool.
About disclaimers. So, should a disclaimer be in each episode's audio, or can it be in the show note description of the show notes / description? Does it need to be said out loud, or can it go in the show notes?
There's no one rule for this. I would say that where you think your listener or your reader would see it, you want it to be apparent. You don't want it to be hidden in the fine print or buried in your terms of use or terms and conditions page on your website. Having it in the show notes, I think, is a great practice. You could have a disclaimer, at the beginning of your episode if you feel like it's appropriate, depending on the subject matter, or you could have it at the end of the episode if you think that is more appropriate, depending on the subject matter. I would say if you're the higher risk and sensitivity involved in the subject matter may warrant having it at the beginning and in the audio, as opposed to, if it's a lower risk situation, and depending on the subject matter and depending on the actual subject and content within your broadcasts, having it in the show notes might be perfectly fine.
Great. So that was also in our one of the questions, if it should be at the beginning or the end of an episode. And cool. Do you know a place to find any standard disclaimer language?
Yes, we actually have them on our website at coachesandcompany.com. Yeah, you're able to purchase disclaimers. We have a disclaimer pack, and that way you can pick and choose what makes the most sense depending on the subject matter and the nature of the podcast and the content that you're presenting, whether it's in the form of a podcast, in the form of a live training, if you're leading a webinar like this one, or maybe if you're, hosting your own trainings or workshops, you can include them there. You could put it on a website, and more. Yeah, there's a lot more that can be said about disclaimers for sure.
So I kind of want to switch gears here for a second, because I also wanted to ask, we're talking about protecting other people's property and not kind of infringing on their intellectual property, but how do you protect yourself? How can creators protect their own intellectual property so that other creators might not be using it or might not be repurposing it in a way that could kind of infringe on their privacy in that way?
Yes. So intellectual property is definitely a game of being proactive. You don't want to have to wait and be reactive. You never want to be in a situation where the only option you have is to be reactive. And being proactive requires that you do it ahead of time, not waiting until what hits the fan and you're having to do the damage control, you're having to clean up the mess, maybe hire a law firm. That can get expensive. It can be very stressful as a situation overall. So being proactive when it comes to your IP is critical. And ways that you can be proactive is by having those notices apparent around the use of your content. So if you are an adult, you've probably seen a copyright notice. It has the circled C and a year next to it. And if there's a book within reach of you right now, if you open up the book and in those first few pages, there's a lot of print on that first page or two, and you'll find, are you looking for a book? Nice.
Yes, I was. Don't have one in reach. I love that you saw that. I was like, books, where?
Well, if you do have a book within reach, you'll find that copyright notice that states it has that circled C symbol, and then it has a year, and that's the year that the copyright came into existence, when it was created. And then typically it has the entity that owns the use of that copyright. And when you own a copyright asset, you have the exclusive rights to the use of it, to publish it, to profit off of it, to license the use of it to others, to create a derivative work based on it or repurpose it in some way. And so your rights are vast, and this is a really valuable asset. And that kind of sidetracked, but also really relevant, is my belief that content creation is asset creation, and it's true. Each time you are creating content, you're creating a written work, a visual work, an audio-based work, you are creating assets within your business. And that, I guess, then it's like, are you viewing what you're doing right now as a business, or are you not? I don't know. I imagine that's a thing in the podcast community too, because I see a lot of discussion around that as some people start a podcast out of hobby and passion and excitement to, share a perspective and share a voice. And then there are some that are using it, deliberately and intentionally as a part of their business execution strategy. And so that I feel like is another conversation, maybe for another day. I would love to talk about that too. But being mindful of, where you are displaying all of these copyright notices and making notice and making putting the public on notice in terms of somebody owns the rights to this content. This isn't, up for grabs. It's not a part of the public domain, which is like content that exists in, like, anybody can use it commercially or personally and no license is needed. So putting others on notice in that way can be helpful. With respect to your podcast, if we're speaking just when it comes to our podcasts, but when you are publishing any type of work, in terms of a written work, an audio work, a visual work, publishing on your website, content on your blog, sending out emails, posting on social, if you're publishing a physical book, if you're leading a training or you have some recorded trainings and workshops that you publish and maybe sell access to online, all of that is original content that belongs to you. And so being really clear, and this is the point I'm getting to here, is have the contract in place between you and everybody who's accessing your content. And that is one of the best ways that you can be proactive, because in that contract, you state what content you're providing access to and what their rights are when it comes to the use of it. Can they use that personally? Or can they publish it themselves? Or can they take it and white label it as their own and sell it commercially? There's no right or wrong answer in your podcast, within the context of your podcast. Of course, that's highly unlikely that that's the arrangement you want to have with your listener. But in some, other forms of content, maybe you are creating an asset and licensing the use of it to others for them to use personally, or maybe you're providing access to it for them to take and commercialize on their own and include it as a part of their process. And I mean, there are many different examples that we could get into, as it relates to licensing of content and resources. I'd love to hear more about, those of you in the chat, the kinds of, if you have a business presently tied to your podcast, or if your podcast is connected to a business, I would love to hear about what kinds of things you're selling and if you're selling anything digitally.
And while you're answering that, we have a question. Does one have to fill out paperwork to have something copyrighted, or is it taken care of once you publish? Because we were talking before about when your work is published, that you're putting it out there and then everybody owns work. So how does that work?
Yeah, great question. So the moment you create a work, an original work, you have the copyright to it. You own the copyright asset. You own the copyright rights tied to that asset. And so you don't have to register it, although you can. Registering it can be helpful in that it puts it in a permanent form, if you will, in terms of what exactly you are claiming exclusive rights to. And if you find yourself needing to pursue a legal action against somebody in a court of law, you have to have the copyright that is the subject of the lawsuit. It has to be registered with the Copyright Office. And so it can be helpful to do that. Now, it doesn't necessarily make total sense to register every single piece of content in your business. And maybe some of you are thinking that right now as you hear it, like, hold on, I got to register everything. Like, I have a lot. And so it doesn't necessarily make sense. But if you have a piece of content that is a core part of your business, for example, if you wrote a book, back to the book example, if you wrote a book and this is the core part of your body of work, or maybe that is your main driver of revenue. Maybe it's an online course and that's your main driver of revenue. Then it might make sense to copyright that, to register that as a copyright, because the more you are, how should I state this? The more revenue that product generates, the greater surface area there is for a potential copyright infringement issue. So the more people that are accessing a piece of content, the more likely and the higher value it is. There's like some sort of chart I need to actually create that illustrates this point. That like the higher the value of the content and also the more transactions that are taking place within your business. So if thousands of people are seeing this product, then there is a greater surface area of potential copyright infringement issues because more people are gaining access to this content. So if it's a very valuable piece of your body of work, then it might make sense for you to, take that extra step to register the copyright with the U.S. Copyright Office if you're based in the U.S. Or if you are publishing it in the U.S. market, if you're outside of the U.S., you can register a copyright as well.
So I like all of these questions that are coming in are so,
oh my gosh, I want to read them all. I haven't been scrolling. I'll get distracted if I try to read the chat while I was like, chatting with you. Thank you.
One that I wanted to get to that was asked right in the beginning, and I got a few people who had written in about this, were guest forms, guest release forms, co-host release forms. Let's talk about them. Do you always you recommend always having a guest fill out a consent form?
I will say that it is the best practice in my opinion. And the reason why is because it puts in plain writing what the nature of the relationship is. So being a guest on somebody's podcast can be a very casual thing. It doesn't have to be a whole thing. There doesn't have to be a whole lot of promo before or after. There might not be any obligations beyond, hey, show up the day that we've agreed to record, and then you don't have to do anything after that. That might be the beginning and the end of it, right? But when it comes to the podcast itself and the podcast episode itself, you as the podcast producer are going to be investing time and money in the production of this podcast episode. Yeah, it's one podcast episode, but we all probably know that it requires an investment of time and money to some degree to produce each and every podcast episode. So remember, content creation is asset creation. So you are producing an asset. Each episode of your podcast is an asset of your business and of your podcast. And so we've got to make sure we're protecting our assets. And one way that you can do that is by, when you have a guest join you on the podcast, have them sign an agreement that clearly outlines your rights to the use of their likeness. So you'll probably use their voice to promote the podcast episode, or their photo, their headshot, their name to promote the podcast episode. And if there's a commercial aspect to your podcast, then you want to make sure that you're protecting yourself adequately from, for example, if you're promoting the podcast and then that guest, which is probably unlikely, but we have seen it happen, the guest takes issue with your promotion of the podcast. Maybe not necessarily the way you're promoting it, but the fact that you're using their image, the fact that you're using their voice. So you want to be able to, say, okay, well, I have rights to the use of this podcast episode because we produced it and we agreed and we put it in writing, and you understood that I would be promoting the podcast episode. So that is one way that it can, protect you as the podcast producer. Also being clear around who owns the rights to the use of this final episode. Is this something that, you might decide that you want to provide a license to the guest where they can also publish it and reproduce it and use it in any way they want. Or maybe you have the exclusive rights to the reproduction of this podcast episode. Again, there's no right or wrong answer here. It just depends on what your preferences are. And then in terms of, I was at an event in Dallas a few weeks ago, and I met somebody that has a podcast where mimosas are a theme in their podcast.
Love it.
And so they said, we actually film in person here, and they had a studio in downtown Dallas. And they said, we film in person and we provide, adult beverages. But lately I've been thinking, well, I don't want to be responsible for what these people are doing after they leave our studio. And I said, really okay, fair. Well, yeah, you should probably include that in your guest release form. And she said, I don't even have a guest release form. And so I told her at the time, you would probably want to consider having some language around, their whatever actions they take after the end of your studio time and the time that you've agreed to produce the podcast, that, they release you from liability. And also don't overserve them and then send them off on their way, because again, it's two parts. It's not just I put it in writing and now I'm protected. It's put it in writing and then also make sure that you are engaging in best practices, to not put yourself and others at risk. And so you can include language like that also in the guest release form. I would also, another thing I would include, and that's included in our guest release form. We have a guest release form, of course, on our website. I didn't come here intending to reference the contracts this often,
but I think that your website
I feel like it works.
Super helpful for creators. So the more resources that they're able to get to, the better. So yeah, I'm happy to share it.
I appreciate you. That's what we're all about. It's all about accessibility. And in my background as an attorney, I was working with clients for years and found that most new entrepreneurs knew that they needed to legally protect themselves. They just weren't in a position to invest thousands of dollars to hire a law firm. They didn't even know how to find a lawyer that could help them. They didn't know what they didn't know, what questions to ask, etc. So this is, our way of making it more accessible to more new entrepreneurs so that you don't have to learn all the lessons the hard way. You shouldn't have to learn all the lessons the hard way. There's some lessons that you can learn from others and be proactive and avoid them. Yeah. Well, that's what I'm talking about. I think there are legal lessons that can and should be, not learned the hard way. You should learn those the easy way and be proactive.
So a question that I have was actually asked in the chat, and I was thinking about it myself, is like when we're bringing on people to come to a guest to come on our podcast, we're really trying to put as few steps in between them saying yes and us having them on. So if you have a form that you have people fill out digitally, let's say it's like a Google form or something, you have them filled out and they send we've all seen them here's your Instagram, send us your bio, that kind of thing. Is it enough to kind of have a check mark there that says I agree that by coming on, you allow me to use your name and likeness and that type of stuff, and that I'll be publishing this on X, Y, and Z platforms. Is that enough to kind of cover you, or do you think that you need more?
Great question. Oh my gosh, I'm loving all the questions. This is really good. This is an excellent question. So this is talking about click-through agreements. So if you're an adult, you've probably 99.999% of us have engaged in and been party to a click-through agreement when you're at checkout and you check a box to agree to the terms and conditions, and then you can click on it.
I think of Apple. Yes. I think of Apple, the giant, the one that
I'm dude, are you out of your mind?
About it?
Yes. Not me. Definitely not. And so you can check the box and you're able to view the terms and conditions right there, and then you're good to go. That is under the law a binding legal agreement. If you can clearly see everything that you're agreeing to, meaning, that long agreement, as long as you can access it and read it right then and there, and you have an opportunity to do so, and the person expressly takes an action like clicking or writing a signature of some sort, digitally or handwritten. And so, yes, if you have a form, and that is in my opinion, the path of least resistance when inviting a podcast guest to join you on your podcast, and you're sending them a form to collect their speaker information and information included in your show notes, etc., is also have in that form the language around your guest release, that they're consenting to your use of their likeness, that they are, they agree to only present, and this is the point I was going to mention earlier, to only present information that they have, and content that they have the authority to share. So that way, if they're sending you a headshot, they're agreeing that they own the rights to the use of that, and they can provide you with that license to republish that, even just a headshot, and photographers are actually as they should be, very protective of their copyrights and their use of, and the use of in general of their content. I've seen many photographers pursue legal action against others to protect their content. And I've also seen many entrepreneurs run into issues because they don't have the exclusive rights to the use of their photos. Whether you're hiring a photographer to come, photograph a live event that you're hosting, you want to make sure that you have the exclusive rights to the use of those photos. And that's not something that they can license to like a stock photo website or, sell somewhere else. Or maybe you hire a photographer to come take photos of products that you intend to sell online. And then they take those photos and they license them to somebody else who's selling those same products online. If the photographer owns the rights, they are within their rights to do that. So whenever you are hiring others, this is a really important point. And this is a lesson that every entrepreneur learns at some point is when you are hiring others to create content for you, they own the rights to that content and they have to expressly transfer ownership of it to you. And that should be in writing. So if you're hiring them as a contractor and they're providing services to you, maybe it's an agency, maybe it's a freelancer, make sure, can you guys hear me?
Good. Yeah, I can hear you.
Okay, good. I got like a trying to reconnect swirling circle, and that's never a good sign. All right, so we're good. So make sure it's in writing. If you are hiring just create somebody to create content for you, capture photos, video, write copy, create music, make sure they're putting it in writing, the transfer of ownership to you, or a license that is very generous that allows for you to use it all the ways that you want to use it.
And this is actually a perfect segue to a question that I saw from JD and from Anna. So Anna had asked, how about protecting yourself when co-hosting? I've worked in the past with clients who have mentioned it would be important to determine legalities before embarking on it. Is a contract needed? JD had asked, I have a podcast where a few co-hosts that don't own the company, don't do hosting, etc. They just show up for the recording. Should I have something in place to protect my show as a whole from these other hosts?
Excuse me. Great question. Okay, JD. So I don't know the entire scope of your relationship with your other co-hosts, but based on what you shared here, as far as they don't own the company, they don't do the hosting, it sounds like they might not have anything to do with production or, pre-production or post-production. If that's the case, it sounds like they might just be another guest. Maybe they are positioned as a co-host, but generally, if I were having a co-host join me on my show, and they didn't have any ownership interest in the company, and I didn't want them to have any ownership interest in the copyright asset in terms of the podcast episodes that they're a guest on or they're a co-host on, I would put that in writing to make sure that it's really clear to them that they don't have any ownership interest in the show, if you haven't already done that.
Awesome. And we have another question about podcast editors. Do you also think that because in Riverside it's easy to maintain control of the assets, but if downloading and sending them to an editor for a fee, should the editor or the client be protective of ownership of their recording assets?
So if I understand your question, you're asking if you're producing, let's say, your podcast episode in Riverside and you download the file and then you're sending it to an editor to, edit and finalize it for publication. You want to make sure in the contract between you and the editor that you are maintaining all rights to the finished product and to any content that you're producing together. If there's anything that they want to maintain ownership of, maybe, for example, maybe they're an editor who creates their own original on-screen graphics, and those are graphics that maybe they want to be able to use it in other contexts. So maybe in the contract they say, okay, you own the rights to the final product, but the design elements that are being used in the on-screen graphics, I own the rights to it, and I'm providing you with a license to use it within your videos. That's an example. But you can and should put that in writing if that is the case, and if you want to make sure you own the rights to it. If you are sharing an episode with an editor and they are making minor edits, there are not any significant changes where they're creating what would be considered an entire new work, then you are technically asking them to, and at your direction, they are creating a derivative work based on the original work, which is the raw podcast that you produced. And so you'd probably be in the clear in terms of they're not creating a whole new work, so they probably don't have any rights to claim. But this is another case of you want to be proactive. So it's best to just be upfront and clear with everyone you're working with who's handling your content or who is contributing to your IP development, is be really clear as to what their rights are and what your rights are and who can claim ownership and use of the final product you're producing together.
Awesome. I want to also move on to ads, sponsorships, recommendations. So this started with another question from Matthew, legality issues around the recommendation of support services on podcasts. So, for example, talking about sensitive topics, they'll talk about like, here are the main contacts and like for example, like suicide prevention of mentioning a place to go. But then also besides those kinds of recommendations, something that I definitely wanted to touch on was sponsorships and ads. Is there anything that you would recommend along those lines that podcasters should do to make sure that they're protecting themselves and being as transparent as possible?
Yes. So it is important for you to be mindful of FTC regulations, which is the Federal Trade Commission. And the FTC, in a nutshell, requires that if you are promoting a product that you were paid to promote online or you stand to benefit from monetarily. So if you are, promoting an affiliate link for a product that if somebody purchases after seeing your recommendation and they click on that link and that generates a commission for you, you have to make sure that you are disclosing that in the area that they would potentially click. So again, it can't be buried in the fine print or like at the very bottom of the page. Be really clear somewhere around that button or that link that this is an affiliate link and that you stand to make money if they purchase at via that link. And you can let them know that there's no cost to you if you use this. And there's no extra cost if you use this link to purchase your product. But you have to make that disclosure. So that's important, whether you're talking about having affiliate links within your show notes or in your blogs, or that you're shouting out if you have a code or something that's tied to your affiliate account, shouting that out on your podcast. You want to be really clear that there is an affiliate partnership between you and the company. But you can let them know also that I'm only recommending products that I genuinely love and that I think that you will enjoy and benefit from. And so, that's why I became an affiliate. So I think there's something to be said around, whether or not it's okay to promote an affiliate link. I think sometimes it gets a bad rap online. If there's an affiliate link or if they stand to make money, they're only promoting it for that reason. But if you genuinely are sharing products that you love and think that your listeners will also benefit from and enjoy using as well, let them know that. Just be mindful of the requirements to disclose if you do stand to benefit monetarily or if you're running an advertisement for a product or a service that you were paid to run on your show. And get those relationships in writing too. So I think that's another part of it.
Always get it in writing. There's my legal thing.
That's literally it. That if everybody walks away with that, just always get it in writing.
We actually have a follow-up from Matthew who just said that it's interesting about disclosure. I don't suppose people hiding affiliate links and not declaring on social media comments are liable to FCC, or are social platforms protected in that sense?
So the best practice is to always make the disclosure. And technology and the internet and these platforms are ever changing, so whether you're today promoting it in a link in your Instagram bio and you're promoting the products on and asking people to click the link in the captions of your social media posts, or maybe the links are in the descriptions and show notes of your podcast episodes, or they are hyperlinked in the text that is in the description of your YouTube video, or I can keep going. You're linking in your email newsletter. Like there are endless places, and there will continue to be endless places that we can link to affiliate links and sponsored content. The best practice is just always make the disclosure and understand that you could be liable in the event that you do not make the necessary disclosure when promoting in that way.
Well,
Thank you for your question.
Speaking of of
Yeah.
liable, let's talk
Yeah.
about libel. I'm sorry, I was trying to make a
Yes.
good transition there. But we had a few,
Bravo.
thank you, thank you.
You're
So
welcome.
we had a few questions about libel. So for example, one that just came in is when talking about controversial topics, potential conspiracy theories, for example. When can we be liable when talking about certain companies? If so, what's the best way to handle this when we're talking about these topics? Another question is just about that I had written down from before was just about ways that podcasters, I mean, sometimes we could speak off of the cuff, ways that podcasters can avoid being like held accountable for libel or defamation, things like that.
Yeah. Okay. So this is an interesting topic because the nature of podcasting involves commentary, pop culture, observing our culture and the way society handles and reacts to different issues. And so I can see how this would be a fear of, or a concern rather, of podcasters. My approach to this in terms of whether we're talking about, libel or slander or defamation and being a target of legal action. I think that's what it comes down to is we all want to avoid being a target of legal action, right? So I want to be able to speak about a topic or, discuss an event that took place or some activity that I observed online or, in real life. And I want to avoid being the target of a lawsuit. And it's important that you understand that whether you commit those acts or not, you could always be the target of a lawsuit. And I don't say that to scare anybody. I say that to make it very clear is that people can pursue legal action even if they don't have a basis for it. So the best that you can do is to not publish anything that is untrue. So if you are somebody who is, publishing information that is outright false, or an allegation of something that would possibly shock the conscience, be really mindful of how you proceed, because even if they don't have the other party, the person that you're talking about, even if they don't have grounds for, a claim of defamation or a claim of slander, they could still pursue legal action against you. So I would only engage in, talking, I don't know if negatively is the word, but if you're crossing a line, only do that with the knowledge that, okay, whether they have a valid claim or not against me, I need to be prepared that somebody might take action against me. I don't think that's the case of most people. I think most people are not engaging in that kind of behavior or trying to, put the business of others out there or, harshly criticize or publish, possibly untrue statements or information about others. But if you are, just understand that you may or may not cross a line depending on what the context and circumstances are of the situation, whether the situation and the statement that you make is factually true or false. And so you run a risk in that instance. If you are publishing the truth, however, for example, if you're publishing a review of a product or a service that you purchased or used, and maybe it's a negative review, maybe your experience was absolutely horrendous from start to finish, or maybe there was just one really bad part. As long as all of that is true, then you are protected under the law. You are able to, and you have the right to provide an honest review of your experience as a consumer, as purchasing a product or a service. And actually, businesses are prohibited by the law from preventing consumers from providing honest reviews. And so if you read a contract and it says that you cannot write a negative review, that is actually against the law. And that is not permitted. It's against those regulations. So that's something to also keep in mind. But I would say only publish matters that you have personal knowledge of and that have been verified and that are true. And never publish any confidential information. If there's any confidential information that you have access to, never publish that, because that could be a breach of maybe some contractual obligations, or maybe that could result in further harm to the other party, and you could be potentially liable on that front. A bit of a long-winded answer,
No,
so sorry about that, but I hope it was
really helpful. Yeah, no, it definitely is. And then just to make sure that I get to Cindy's question that was sent in, so Cindy is recording in the UK and she's recording with somebody who is somewhere else in Europe. Which jurisdictions' laws apply in this kind of case? Like, what should she be aware of in those kinds of international recordings?
Okay, I'm sorry. So, excuse me, it says, when recording in the UK, for example, and the recorded person is in Europe, which jurisdictions' laws apply? And then was there a second part, or did you just read that? I just spotted it in the chat. That's why.
She sent it right when I was reading it because she had sent it before. So
Okay.
That's funny. Hi,
Yeah,
Cindy.
you're good. Okay, nice. Hey, Cindy.
Then,
okay, nice.
The other
you're
question
good.
was about another topic that we can try to get to before the end of the. But we touched upon it a little bit in the beginning, just about the consequences of using somebody else's recording material that is not consented. But let's start off with the international.
Yeah, you're
law.
good. Thank you. Yeah, sorry. My eye met it the moment you were reading it. And I was like, wait, are we reading the same thing? And did I miss something? But okay, I'm with you. Okay, so this is one of the clauses that you would and should include in your guest release or your guest agreement when you're bringing people onto your podcast. And you include this kind of clause in your client contracts, in your website terms and conditions, in your agreement with employees or contractors, and that is your clause around jurisdiction. And with the jurisdiction clause in all of these contracts, what you're stating is what jurisdictions laws apply. What jurisdictions laws are we going to use in this instance if there is a legal dispute? And I think it kind of goes without saying, but I'm going to say it anyways, is you want a home court advantage in this situation. You don't want to necessarily have to, for example, if your guest is in Europe and you're in the UK, or if you're in, New York and your client or your guest, is in Singapore, you don't want to have to travel to Singapore, or maybe you do. I don't know. It seems really awesome there. I haven't been there, but it sounds great.
Could be a good excuse.
Yeah, it could be a good excuse. But, you don't want to have to travel there I take it back. I would not want to have to go there to defend myself in a court of law. It doesn't sound like a great time. You want for that to be your own local jurisdiction, ideally. Of course, that varies from business to business. Maybe you are incorporated in a different state, or maybe you have, other jurisdictional concerns and reasons why you would want for another jurisdiction's law to apply. But for many entrepreneurs, your local jurisdiction is probably where your business was formed. It's probably where the majority of your business operations and activities take place. And it's possibly where you would most benefit from having a lawsuit in your local jurisdiction where you might already have an attorney, or you are able to easily hire legal representation within that lawsuit. So you get to decide, I guess is my answer, is you should state that in your guest agreement is what, in the event that there is a dispute that arises, you understand that, the laws of, and then whatever jurisdiction you want to have apply in that instance, include that in the contract. I know for some that might, some people might hear that and think that seems like a bit much. I don't necessarily want to send a contract over to every guest. We already talked about creating as little friction as possible when bringing a guest on to your podcast, because, many times you really, really want that guest to come join you on the podcast. So you don't want them to be turned off by a lengthy contract or, all these clauses. But I believe that there is a way to, communicate that professionally and in a way that actually protects all parties and doesn't necessarily, burden them by any means.
And a quick follow-up for the libel question. If a guest makes a non-factual claim, is that on you, or is that because it's on your show?
Potentially, in your contract with the guest, you could ask and ask them to agree to not present any information that they believe to be untrue, or that they do not have the right to or authorization to, publish or discuss. And also you can include in the event, in your agreement with the guest, that in the event that there is a lawsuit brought against the show due to a statement made by the guest on the show that they agree to indemnify you, which means they essentially agree that, okay, if I have a guest on my show and a third party files a lawsuit against my show because of something the guest said, in my agreement with the guest, if I have that indemnification clause, which says, in the event that I'm sued by somebody else, you agree to actually defend against those, and you agree to cover those attorney's fees, and that you will be the party that should be subject of that lawsuit. So that is one approach that, podcasters could consider, is including that. Of course, for most podcasters, I would guess it's probably not necessary depending on the subject matter of your podcast. But if you are a podcast that discusses, pop culture, or you frequently discuss third parties and the activities of other individuals, and that's something that is, of regular programming on your podcast, then you probably would want to have something along those lines, because it sounds like in that instance, it's more likely that you might face a situation of a guest saying something problematic and that you want to protect yourself from as the podcast.
Awesome. And then we are almost at the end, but I wanted to circle back to a question from Anna, who asked, what are your top, we've talked about a bunch of stuff that people can do today, but what would you say are the top 3 legal priorities for podcasters? I know it's hard to pick 3 of
Yeah. Excuse me. Yeah, you're good. Actually, we didn't even get to one point that I expected to receive this question, and maybe we had and we just didn't get to
it. Is it about AI?
No, it's around naming your podcast. But there's so much to talk about in AI too. But it's about naming your podcast. So that is one of the things that is one of the top things that I would have as a consideration as a podcaster, is when you're naming your podcast, that is you selecting your trademark. And trademarks and copyrights are the 2 types of IP that you want to get really familiar with as a content creator in general. And if you have a brand that you're developing, if you're creating content, you have both a trademark asset and probably many copyright assets, maybe more than one trademark. I always like to, and I'll keep this short since we're almost at the top of the hour, I like to visualize a gift or a present or a box of some kind that has wrapping paper or some sort of packaging on the outside. And the packaging on the outside has your source identifiers. It identifies the source of where whatever's in this box, this is where it came from. So that's your company name, your brand name, your logo, your slogan or tagline. Your podcast name can be that source identifier. If you have a hashtag that you use in your marketing materials, that's the first thing the consumer is going to see. And so those are your trademarks. So it's typically a word or a phrase or a symbol if it's a logo, and it identifies the source of the products or services being provided. And so when you open up the box and you look inside, you see the contents of the box, and that's literally your content. And those are your copyright assets. So those source identifiers, the first thing people see, those are your trademarks, name of your podcast, maybe your cover art. If you're using it as a logo, for example, there are different, many different trademarks that can come up in a business, and then your copyright assets. So those are the 2 kinds of IP you want to get really familiar with, as a content creator, as a business owner, and somebody who's developing a brand. And when you're picking the name of your podcast, when you're deciding on that trademark, you want to make sure that you are the only one using it. You want to make sure you're not going to be committing infringement and using a podcast name that already exists. And I know that a few of you will search your podcast after this and see if there is anybody else that's using it, and there might be, and that's not the end of the world. So don't fret. There might be many people using the same podcast name as you. And if that is the case, you might be able to continue using the name and it's not a problem, but you might not be able to claim exclusive rights to the use of it if it's already become what we call diluted, where many people are already using it. It's impossible to say that this trademark identifies specifically one source of this product or of this service. So when you're selecting your podcast name, it's a great idea to go with something that is distinct, something that's unique, something that nobody else is using in the market in connection with something similar, and then securing exclusive rights to the use of it, where you have a registered trademark where the government states you have the exclusive rights to the use of it, and then you're able to use that to enforce your rights and to stop others from using that same trademark as another podcast. So that is one thing I would say before you select a podcast name. Do a trademark clearance search. Make sure, and you can search on Google, you can search on all the podcast players, and then you can also search at uspto.gov. That's US Patent and Trademark Office, uspto.gov. You can do a free trademark clearance search there, and you'll look for other registrations or pending registrations for a similar trademark that's similar to the name that you're considering. And if you don't find anything, then you might be in the clear. If you do find something that's similar, that might be a sign to go in a different direction.
Excuse me. If you already have a podcast, I'll ask this one very quickly because we're at the top of the hour. But if you already have a podcast with a name and somebody else has a podcast name, does that necessarily mean that you need to change your podcast name? Or I guess maybe it depends.
It depends if you want to consider who is using it first. If it's one other party and you were using it first, then you might be well positioned to enforce your rights as the person who is using it first. In the US, it's based on first use, the rights that exist in connection with a trademark. So if you and one other person or maybe two other podcasts exist and they're using names that are identical to yours and you were using it first, you might be in a position to stop their use and to enforce your rights. If you were in use after them, then you might actually be the one committing infringement. So that's the situation everyone always wants to avoid when it comes to your trademark, is you want to avoid the forced rebranding, but it's a possibility. And then if you find yourself using a trademark and there are, dozens of others who are using a same or similar trademark, then the mark itself might be diluted, meaning nobody can claim exclusive rights to the use of it. So you might want to, consider rebranding if that's important to you and you want to be more distinct and be, searchable and findable easily on the internet and in podcast players. Or maybe you decide, I'm fine with it. I think it's okay. And I'm not, causing harm to anybody. I'm not committing infringement against anybody else. And I've invested a lot in the name at this point. So maybe I'll just want to keep it.
Perfect. Well, thank you very much to everyone for all of your questions. I know I have a ton more, but we are out of time. But I did just want to say thank you so much, Yasmine, for joining us. And I also just want to give a shout out. It's Coaches and Company. I'm going to put that again in the chat. And there are instantly downloadable contract templates for podcast guests, podcast production services, social media services, one-on-one coaching, group coaching, masterminds and workshops, stuff that I know a lot of you are working on, like live events. So feel free to check that out if you want to hear, and also if you want to hear more from Yasmine. And then I also just want to give a quick shout out to our community groups. If you want to continue the conversation, we have community groups on Facebook and on Discord where you can ask each other questions. And the other week we were having a discussion about guest forums. So a really great place to also continue having these conversations. And as always, if you have any other questions that you want to ask me, you can always reach out to Kendall, Kendall, at riverside.fm. And with that, thank you all so much for joining us. Thank you for your questions. And I hope this was useful and valuable for all of you.
Thank you.
Thanks. Bye, guys.
Bye.